Good morning, and today we are going to talk about the connection between mortgage foreclosure and Native American title. Now, there have been tons of cases in America recently, especially the one in October of 2014 called the Jesnowski versus Bank of America. Now, the first thing you've got to remember is when you sign your sale and purchase agreement, you are signing a deed of trust. In 22 states in America, they have what's known as deed of trust states. So when you sign your deed of trust, you have automatically created a trustee sale. It's like a cognate note, a confession of judgment. If you're 10 minutes late in paying your monthly mortgage, the foreclosure notice is right there at your doorstep. Now, the second thing that happens when you sign your sale and your purchase agreement is that it becomes a security instrument, but they don't tell you what a security instrument is all about. That's when they securitize your realty. If your house is worth $700,000, I can prove to you that they have securitized it to at least $800 million with no money coming to you, no benefits coming to you, no advantages for you. You just keep paying the monthly mortgage. You're enslaved for the next 30 years. The third thing you must remember is when they come to evict you or foreclose you, and yes, I do have an active dog here, I think the dog thought there was a mortgage service guy here, and that's not so. Because my home is fully paid for. Anyway, the third thing that happens is when someone comes to foreclose and evict you, they have to show superior, valid, good title. Unfortunately, they cannot do that because the only known superior, good, valid title is Aboriginal title. Fee simple, land patent, allodium, land grants are legal fictions. What is a legal fiction? The distance from Seattle to New York is about 9 inches on a map. The actual distance is 3,400 miles. That's a legal fiction. So land patent, fee simple, allodial title, and land grants are legal fictions. Aboriginal title is usucapion, U-S-U-C-A-P-I-O-N, which means ownership due to lengthened possession. So when the forecloser comes after you, he doesn't even have good title. Now, unless Indian title is extinguished, it is still Indian country. That's not an opinion from me. That is federal law. 18 United States Code, Section 1151. Go ahead and Google it. 18 United States Code, Section 1151. It tells you clearly, unequivocally, unambiguously what Indian country means and what Indian title is. The fourth thing you must remember is in California, for example, you have what's known as, and in 21 other states, non-foreclosure judicial sale. Now, in these states, judges are relying on an unconstitutional law to give creditor relief. State judges take their oaths of office based on state constitutions and the United States Constitution. So when they give creditor relief based on an unconstitutional law, what have they done? They have violated their oaths of office. So the tribal court has been telling these people, or tribal lawyers, when a homeowner is being sued or when is about to lose their homes, what we tell the judge is in state court, You cannot do that because you're violating your oath of office. You have to wait for the legislature to amend the offending statute. Until that happens, you cannot give creditor relief. It's as simple as that. So, 1, inferior title. 2, failure to disclose. They haven't told you what a mortgage deed of trust is. They haven't told you that they're going to securitize your note. They haven't told you how many times they're going to sell your note. All this is disclosure. Disclosure is part and parcel of the Truth in Lending Act and the Home Ownership Equity Protection Act. They don't tell you that. And that is a no-no under federal law. Secondly, they don't have valid title. If Indian title has not been extinguished, they have no right to foreclose or evict. Thirdly, non-judicial foreclosure sales are an affront to due process, equal protection of the laws, 14th Amendment, and state judges cannot give creditor relief based on an unconstitutional law simply because they took their oath of office based on a state and the federal constitution. So for homeowners, for those of you who have been foreclosed, who've lost your properties 10 years ago, the Native American Law and Justice Center is willing to fight for you. For those of you who are facing foreclosure, facing imminent eviction, we can help you. And for those of you who are still current in your monthly payments, send the county tax assessor a lovely letter which I will help you put together. It's already done. All you got to do is call the office, email us, we'll send you the letter. That letter asks the county tax assessor, can you show me when Indian title was extinguished? I guarantee you this, folks, they can never, ever prove or evidence when Indian title was extinguished. I'm talking about California, for example, because when California became a state on September 9th, 1850, a year or two later, they passed the Land Claims Act and told every Indian in California, you have 2 years to come and stake a claim. And most of those Indians in 1850 California, their laptops were not working, their fax machines were not working, their smoke signals were not working. Nobody knew that they had to file a claim within 2 years. Failure to disclose. So give us a call, send us an email, call us at 714-928-6914, 626-428-7669, or you may even call us at 417-691-5009. Our team is ready, willing, able, and capable to prove the fraud. So, we are here to help you. Our next session will be on immigration. So stay tuned. Thank you very much.